When I handle cases, God is always on the throne. In the case of Nnamdi Kanu, God has taken over the entire proceedings. There's no question about that. You all saw it in court today. The truth is that the lower court tried in striking out 8 out of the 15 amended count charge. But the lower court fell far short in not striking out the remaining 7, which have no business being in the charge sheet. All the 7 remaining counts are watery, prima facie. They are dead on arrival, and they were dead on arrival, as I termed them, as dead as dodo. But instead of the lower court striking out the entire 15 count charge and allowing Nnamdi Kanu to go home a free man after the long walk, like Nelson Mandela, long walk to freedom, the lower court retained 7 of the counts. And we are here to say, intermediate court, court of appeal, strike out these remaining 7 counts, because the lower court never calmly looked at the documentary evidence we placed before it. The respondent, the federal government, the DSS, they never responded to the critical issues we raised, that Nnamdi Kanu was forcefully abducted in Kenya. And the law is that when you want to take a person from another country like Nnamdi Kanu from Kenya, you have to go through a certain extradition procedure. If you don't, the detaining authority, that is Kenya, have to first give you consent or permission that you can take away this subject from our jurisdiction. Kenya did not do that. In fact, Kenya said, we never told them to take Nnamdi Kanu away from here. So what the government did was to apply brute force, Vietnamese, in a most savage manner, by capturing Nnamdi Kanu the same way the federal government had done against Umaru Diko, who was Shagari's minister. And we have cited several cases before the court in other jurisdictions to show that a person you have brought in forcefully cannot stand trial on counts that were existing before you brought him back, which did not amount to the offense you are now saying he has committed. And by the way, the Federal High Court Act, the Administration of Criminal Justice Act, and Supreme Court and Court of Appeal decisions say when you are charging a person for a criminal offense, you must state with particulars the place where he allegedly committed the offense, the time, the venue. But in this case, all the remaining 7 counts, they are saying, 6 of them, that Nnamdi Kanu made certain broadcasts. Broadcasts from where? From the spirit world, you did not tell us. From Ghostland, you did not tell us. And you know what they did? That was because in an earlier objection to the first charge, where they said he made the broadcast from the United Kingdom, they tried to run away from that by now saying he made the broadcast without stating where he made the broadcast from. And the law is that you cannot charge a person in such a vague and invasive manner. The Federal High Court does not have global jurisdiction over crimes allegedly committed in other parts of Nigeria. The only count that they mentioned a venue was one of the counts where he was accused of importing a transmitter, and that it was accosted at Obolo Isuzo in Ihiala local government area of Anambra State. Of course, Ihiala local government area of Anambra State is not within the jurisdiction of the Federal High Court, such as to preside over the matter against Nnamdi Kanu in that respect. There is another point also, which is that he is being tried for allegedly committing these acts as a member or leader of IPOB. Because according to the federal government, IPOB has been banned or proscribed. Meanwhile, we have since filed an appeal against this proscription. And the appeal is pending, is extant before the same court at the Court of Appeal. And you cannot begin to carry out a charge against a person based on a foundation which we are telling the Court of Appeal to remove. The question you should ask yourself is simple. Were Nnamdi Kanu to be tried and convicted, God forbid, and the Court of Appeal later finds out or discovers that IPOB was illegally and unlawfully and wrongfully proscribed, what do you do about that? So we are saying the law is that they should wait under the doctrine of least pending. They should wait first for this court to determine whether it was lawful or illegal. And they are jumping the gun. So all in all, Nnamdi Kanu has no case against him at all. He is being kept in detention by the same DSS who investigated him, the same DSS who arrested him, the same DSS is detaining him, the same DSS is still keeping him in custody, the same DSS through the federal government is also prosecuting him. So where is the justice when you are the investigator, the arrestor, the accuser, and the prosecutor? Where is the justice? Justice is not only for the government, it is also for citizens like Nnamdi Kanu. Nnamdi Kanu has not done anything wrong, and we have been able to demonstrate before in our book